Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And over here you can find previous year solved question papers of several states, year wise and subject wise as well. AIB All India Bar Examination, which is the mandatory requirement for an advocate to pass in order to practice in the court. We will discuss all the All India Bar Examination AIB papers from 2011. So if you are an advocate and you want to practice in the courts, it is mandatory requirement that you should obtain a certificate of practice. And every advocate from our country shall have to pass this exam after 2011. So AIB started in 2011 and this usually happened twice a year. Once in February, another exam in October. However, sometimes it happens that due to some reasons it happens or it won't happen in a year. For example, in 2022, the exam happened in Feb 2023 and no exam was held in whole year of year 2022. On this channel, I am going to discuss the AIB exam papers in Hindi as well as in English. Because every advocate in this country, whether he is from Jammu Kashmir or from Tamil Nadu or Kerala or from Gujarat or Northeastern state, every advocate has to give this exam who is taking degree nowadays. And many places it has been seen that many people do not understand the Hindi. So first we will discuss in English and then later on we will do it in Hindi as well. So friends, we have already started our AIBE series, All India Bar Examination series, and we have already discussed the 17th AIB exam paper in our previous video. In today's video, we are going to discuss the 16th All India Bar Examination, which was held in October 2021. So friends, if you are preparing for AIB exam, this videos will be very helpful for you. And I hope this will help you in your preparation for AIB and also in other judicial services exams. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon, so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. मिनिमम इज 40 रुपीज. सो डोंट फॉरगेट टू गिव अस अ सुपर थैंक्स. सो नाउ लेट्स मूव टू द क्वेश्चन पेपर. You can see the paper comes like this. Question number 1 is, how many kinds of presumptions are there as classified by the Supreme Court? Presumption of facts, permissive presumptions or presumption of facts, compelling presumptions or presumption of laws, rebuttable presumptions हैं ये सारी, and irrebuttable presumptions of law or conclusive presumptions. All of them, D is the answer. There are three types of presumptions. First is fact, law or mixed presumption. But in terms of rebuttable and irrebuttable presumption, there is further differentiation in that. So D is the answer. Next is 2. What is the leading question in the case of Maneka Gandhi versus Union of India? Right of hearing या फिर separation of power? Right of hearing. A is the answer. Next is 3. Advocates Act 1961 came into force on 19th May 1961. A is the answer. Next is 4. Harboring an offender who has escaped from custody or whose apprehension has been ordered if the offence be capital is dealt under 216 IPC. B is the answer. Next is 5. The maxim actis non facere nisi mancitria means this is the first thing you learn while doing criminal law. Without this maxim, learning criminal law is just foolishness. If you do not know this maxim, then it means you don't have knowledge. This is the first requirement. What it means, there can be no crime without a guilty intent or guilty mind. A is the answer. Next is 6. Law laid down under section 73 of Indian Contract Act is related to which of the following cases? Headley versus Baxendale. ये Headley है. C is the answer. Dickinson versus Dodds है ये. And this is Hochester versus De La Tour. There are so many spelling mistakes in the paper, and it always happen. Not just this time. In this question, C is the answer. Next is 7. Hindu Marriage Act 1955 dash petition, in which decree for restitution of conjugal right has been passed to apply the court for decree of divorce by showing that there has been no restitution of conjugal rights as between the parties of marriage for a period of 1 year or after passing of the decree. Does permit any party to that, या फिर does not permit party against whom the, now see this is incomplete, does permit any party to that. C is the answer. Next is 8. The offences under prohibition of Child Marriage Act are cognizable and non-bailable. C is the answer. Next is 9. In case of land acquisition by central government for public-private partnership project, consent of how many affected families is mandated by LARR Act? 70%. B is the answer. This is mentioned in section 2 of LARR Act. LARR stands for Land Acquisition, Rehabilitation and Resettlement Act. And if it is in case of establishing a private company, then it is 80%. Next is 10. A company which is not domestic company will pay income tax at the rate of 40%. C is the answer. Next is 11. As per section 53 of IPC, the word injury. This question has been deleted. Why? Because injury is mentioned in section 44. 53 mentions about punishments. Anyways, if the question comes again like this, so injury includes body, mind, reputation, all of the above. D would be the answer. Next is 12. Which of the following cases can be cured under section 465 CRPC? What section 465 says that no sentence or order passed by a court of competent jurisdiction shall be reversed unless and until a failure of justice has been in fact been occasioned thereby. So in option A, entertaining of complaint without complying with section 195 and 340. So can this be cured? No. Reading and recording of evidence taken in one case into another companion case. See, there are two cases. So the evidence of this case has been read in this one. But they have not mentioned that any decision is taken on the basis of wrong evidence taken. So it means this can be cured. It was just a simple mistake of facts. So it can be cured. Examination of witness in absence of accused, no. Non-compliance with 235(2). But 235(2) says compliance with section 360, probation of offender and all that. So I would say the B would be the answer, which can be cured. Next, 13. Which of the following statement hold true for de novo trials? De novo trial means trial starts afresh. Means you are restarting the trial from inception. Now this thing irritates me so much. How? Half question is mentioned here, half is on top, half is here, half is on another page. I don't understand why these people do this. So omission or illegality in procedure, even if it does not affect the core of the case, can become ground for calling de novo trial. No, a de novo trial should be the last resort. This is totally correct. Court originally trying the case can order de novo. No. B is the answer. Next, 14. Protection against arrest and detention in certain cases is mentioned in which of the following articles of Indian Constitution? Article 22. C is the answer. It is a fundamental right. Next, 15. Article 300A of Indian Constitution. Right to property has been inserted in the Constitution by 44th Amendment Act. A is the answer. 19(1)(f) was deleted and inserted as 300A by this amendment. Next, 16. Which of the following section of Muslim Personal Law Shariat Application Act has been repealed, amended by section 6 of Dissolution of Muslim Marriage Act 1939? That was section 5. B is the answer. Next, 17. A railway servant was killed in a bus accident during the course of employment. His family member may claim compensation under Motor Vehicle Act या फिर Employee Compensation Act. So either Motor Vehicle Act or this one. They have option D is the answer. They have not even given some space so that we can see the next question. This is 18. Casting couch in Bollywood, the Indian film industry, is an example of sexual assault या फिर sexual harassment. Both. Sexual harassment. B is the answer. This is 19. Promissory estoppel against government agencies is decided in Pranami oil mills versus state of Kerala. C is the answer. यहाँ पे all mill लिखा हुआ है, oil है. Okay. Next is 20. Frustration of contract is provided by which section of the Indian Contract Act? It is section 56. D is the answer. Definition of consideration. 73 for breach of contract, and 70 is obligation of person for non-gratuitous act. Next 21. Schedule 2 of Employees Compensation Act 1923 deals with list of persons who are included in the definition of employee. B is the answer. A factor for calculating the amount of compensation. This is schedule 4. List of occupational disease. This is schedule 3 and this is schedule 1. Next 22. Reference to the arbitration is provided in which section of Arbitration Conciliation Act? In section 8. B is the answer. Next 23. Under the head subsequent conduct, which of the following type of conduct would be material? Change of life, evasion of justice, fear, trembling. All of them. D is the answer. And where is the relevancy of conduct is mentioned? It is mentioned in Evidence Act section 8. Next 24. A plaintiff has to be presented to the court under order 6 rule 1 in duplicate. B is the answer. Next 25. Omission to give notice under order 21 rule 22 will. This question was also deleted. Next 26. Where a decree is passed against Union of India or state for the act done in official capacity of the person concerned under section 82 CPC, execution shall not be issued on any such decree unless a decree remains unsatisfied for a period of 3 months from date of decree. A is the answer. Next 27. Freedom of residence under Article 19 of Indian Constitution is available in which of the following clauses? It is in 19(1)(e). A is the answer. D is move freely throughout territory of India. B is assemble peaceably and without arms. And C is to form association or union. Next 28. Under which section of Indian Evidence Act admissions are defined? Section 17. A is the answer. Next 29. In which of the following case Supreme Court held that investigation officer should be allowed to refer to records of investigation? It was State of Karnataka versus Yerappa Reddy. A is the answer. Next 30. Recovery of specific immovable property may be obtained by CPC within what period? I would say this question is also wrongly framed. How? Now the options are as per the SRA. However, possession can also be obtained in 12 years and also in 6 months. It is for dispossession, but it is not mentioned here. So I would say the question is wrong. Next 31. Who appoints the Commissioner for Rehabilitation and Resettlement under the LARR Act? So state government. D is the answer. And where the commissioner appointment is mentioned in section 44 of LARR Act. Next 32. If a party who obtain an order for leave to amend pleading does not amend the same within how many days, he shall not be permitted to do that without the leave of the court? Within 14 days. B is the answer. It is mentioned where? Order 6, Rule 18. Next 33. Punishment of advocates for misconduct has been given under which section of Advocate Act? Under 35. C is the answer. Next question number 34. Under which section of IPC professional negligence is often invoked against medical professionals in cases alleging professional negligence? That is 304A, death by negligence. B is the answer. Next 35. A offers a bribe to B, a public servant, as reward for showing A some favor in exercise of B's official function. B accepts the bribe. A has abetted the offense defined in section 161 IPC. B is the answer. And this is illustration to section 109 IPC in abatement. Next 36, when perpetual injunction may be granted. It is mentioned in section 38 Specific Relief Act. So where defendant is a trustee of property to the plaintiff, yes, it can be granted. Where there is no standard for ascertaining the actual damage, yes. Compensation in money would not afford adequate relief. This is also correct. All of the above. D is the answer. Next 37. A company wishes to ensure that no one else can use their logo. So that is trademark. B is the answer. Next 38. The section of Arbitration and Conciliation Act dealing with time of commencement of arbitral proceedings is section 21. B is the answer. Next 39. Amount of deduction under section 24 of the Income Tax Act from annual value is 3/10 of annual value. C is the answer. Direct provision से ही questions हैं. Next 40. The test of reasonableness is not wholly test and its counters are fairly indicated by the Constitution. So dash test. Which test it is? It is subjective test. A is the answer. Next 41. The power to enact a law relating to the citizenship of India is left to the Parliament under the provision of Article 11 of the Indian Constitution. D is the answer. Next 42. The payment of compensation to railway employees by railway administration for injury by accident is governed by Employees Compensation Act. A is the answer. Next 43. The minimum amount of compensation payable under Employees Compensation Act 1923 in case of total permanent disablement of a railway servant due to accident is rupees 1,40,000. C is the answer. Next 44. The bond under section 109 CRPC as security for good behavior from suspected person can be executed for a period not exceeding 1 year. C is the answer. See, I have discussed this thing several times in my previous videos of judicial services and other exams, and I have also made a chart for this. A small chart is there. Section is 106, 107, 108, 109 and 110. So the period for execution of bond is 3 year, 1 year, 1 year, 1 year and 3 year. And who can give? In 106, Court of Session, Judicial Magistrate First Class and all EM, Executive Magistrate. 106 is on conviction in other cases. 108 in seditious matter. 109 in suspected person and 110 is for habitual offenders. So this is a small chart. Whenever you are going in an exam, just write this chart on the rough paper or rough space in the exam paper so that you would not forget it at the time of solving the questions. Next is 45. The maximum limit of rupees 500 that could be paid to the wife as maintenance under section 125 CRPC was removed. In section 125 there is no maximum or minimum limit for amount of maintenance. Earlier there was maximum limit, but it has been deleted by the 2001 amendment. 1 is the answer. Next 46. The term WIPO stands for World Intellectual Property Organization. B is the answer. Next is 47. Provision of section 10 of CPCR. Directory or mandatory or discretionary? It is mandatory. B is the answer. Next 48. Constructive res judicata is contained in which of the following? In explanation 4 to section 11. B is the answer. Next 49. The famous pronouncement of Delhi High Court regarding the constitutional validity of section 377 IPC reversed in Supreme Court in Suresh Kumar Kaushal versus Naz Foundation. I don't understand that why they are asking the old question, and this case has also been overruled by Navtej Singh Johar case versus Union of India. I think they have just taken this question from the previous year question papers. So D was the answer. Next is 50. Under CRPC, who shall record the information of rape being given by a rape victim? A woman police officer or any woman officer? D is the answer. And where this is mentioned? In section 154, subsection 1, proviso. Next 51. Under the provision of CRPC, summons can be oral. No, summons cannot be served on corporate entities. It can be served. Both are wrong. So summons are either appearance or for producing a document or thing. This is correct. Summons can be served to the servant in case of person whose name summons are made cannot be found. No, it is wrong. So C is the answer. Next 52. Every person who is a member of a defense service or hold any civil post under union holds office during the pleasure of president. B is the answer. Next 53. An arbitration proceeding is a quasi-judicial proceedings. B is the answer. Next 54. What is ad hoc arbitration? It is a proceeding administered by the parties themselves with rules created solely for that specific case. This is correct. Parties make their own arrangement with respect to all aspects of the arbitration, include laws and rules. Yes. Seal of arbitration, the language and scope of issues to be resolved by means of arbitration. This is correct. All are correct. D is the answer. Next 55. Which of the following section of CPC defines mean profit? It is in section 212. D is the answer. 24 is district. 214 is order. 26 is foreign judgment. Next 56. On which of the following dates did Hindu Marriage Act 1955 come into operation? On 18th May 1955. A is the answer. Next 57. Which of the following properties will section 30 of Hindu Succession Act govern? Tarwad, Tawarzi, Kutumb, Kavru, Ilom. All of the above. D is the answer. Next 58. An advocate is under an obligation to uphold the rule of law and ensure that the public justice system is enabled to function at its full potential. Any violation of the principle of professional ethic by an advocate is unfortunate and unacceptable. Ignoring even a minor violation misconduct militates against the fundamental foundation of the public justice system. It was said in case of O.P. Sharma versus High Court of Punjab and Haryana. B is the answer. Next is 59. Section 8 of Companies Act contains provision relating to formation of companies and charitable objects. B is the answer. Next 60. The verification of the registered office shall be furnished to the registrar with a period of 30 days. A is the answer. And where this is mentioned, it is mentioned in section 12(2) of Companies Act. Next 61. Cyber law deals with all activities concerning the internet. IPR, e-commerce, all of the above. D is the answer. Next 62. According to section 2 of Motor Vehicle Act 1988, the term motor cab means any motor vehicle constructed or adapted to carry out not more than 6 passengers or excluding the driver. D is the answer. And this is defined in section 225 of Motor Vehicle Act. Next 63. The National Commission of Consumer Protection is composed of 5 members. B is the answer. And where this is mentioned, it is mentioned in section 54 of Consumer Protection Act 2019. Next 64. Which of the following statement are false for the purpose of Hindu Marriage Act? It is assumed that a person who is not Muslim, Santhal, Christian, Jew or Parsi by religion is Hindu. This is correct. Next is a person who belongs to Lingayat subsect is assumed to be Hindu. It is not correct. Then a person converted to another religion need to follow local ritual or customs for converting back to Hinduism. It is correct. So 1 and 3 are correct. So D is the answer. 1 and 3 are correct. So where this is mentioned, it is mentioned in section 2 of Hindu Marriage Act. Not exactly mentioned, but statement 1 is mentioned, statement 2 is mentioned. In reverse, how Lingayat is mentioned, subsect is not mentioned. So this is wrong. Next 65. Provision for settlement of disputes outside court has been provided under section 89 CPC. B is the answer. Next 66. The Evidence Act came into force on 1st September 1872. D is the answer. Next 67. According to the provision of Article 315 of Indian Constitution, there shall be a Public Service Commission for the Union and for each state. This is correct. The Public Service Commission for the Union, if requested to do by the governor of state, may, with the approval of the president, agree to serve all or any of the needs of the state. This is also correct. So both are correct. C is the answer. 1 and 2. Article is mentioned here. Next 68. Which of the following section of Hindu Adoption Maintenance Act deals with amount of maintenance? That is section 23. C is the answer. Next 69. In which of the following case the Supreme Court first of all made an attempt to look into the question regarding the extension of the right to life to the right to health and other hygienic conditions? The Rural Litigation and Entitlement Kendra versus State of UP. A is the answer. Next is 70. Basel Convention is associated with one of the following. It is related to the control of transboundary movement of hazardous waste and their disposal. D is the answer. Next 71. Cybercrime is intangible in nature. B is the answer. Next 72. Health and education cess is applicable to all SSCs. A is the answer. Next 73. Contractual liability arises where there is offer and acceptance only, or there is intention to create a legal relationship. This is correct. There is loss to one party in gain to another. No. B is the answer. Next 74. The rule of strict liability is based on decision Ryland versus Fletcher. C is the answer. Next 75. The rule of last opportunity was laid down in Davis versus Mann. A is the answer. Next 76. In the light of the following, in which of the following cases it was held that the rights conferred under Section 25 of Hindu Adoption and Maintenance Act supersedes any contract to the contrary, the fact of the date of decree makes no difference? This was held in Sesi Ammal versus Thayu Ammal. C is the answer. Next 77. The phrase file a PIL ostensibly in public interest but in fact to serve personal or private interest means filing PIL for protection of only public interest, no, both public private, only private, or filing PIL alleging it to be public interest but actually seeking protection of private interest. D is the answer. Next 78. Filing frivolous PIL results in increasing backlog of cases, yes. Wastage of resources, yes. Lesser availability of time for hearing other genuine cases, yes. D is the answer. Next 79. Z under the influence of madness attempts to kill X. Is Z guilty of an offense? Has X the same right of private defense which he would have if Z were sane? Z has not committed any offense as per 98 IPC and the same right of private defense to X if Z is mad. This is correct. No right of right, no, it is wrong. Has committed an offense, no. A is the answer. It is section in 98 IPC. Next 80. Admission can broadly be categorized into judicial, extrajudicial. D is the answer. Both A and B. Next 81. Section 66 of Evidence Act lays down a notice must be given before secondary evidence can be received under Section 65A. This is correct. Notice to produce a document must be in writing, yes. Order 9 Rule 15 CPC prescribes the kinds of notice to produce a document. No, this is wrong. So 2 are correct and all of them is not an option. So A and B both are correct and this question was also deleted due to this reason. Next 82. Maxim res ipsa loquitur means a thing speaks for itself. A is the answer. Next 83. Any private person may arrest any person who commits a non-bailable offense in his presence if a non-bailable offense and cognizable offense in his presence. B is the answer. Section is 43 CRPC. Next 84. How long a warrant of arrest shall remain in force? Until executed or cancelled. D is the answer. It is mentioned in section 70 CRPC. Next 85. Rate of additional depreciation will be dash under section 32 of Income Tax Act. That is 20%. B is the answer. Next 86. The committee which led to passing of Criminal Law Amendment Act 2013 was headed by Justice Verma. C is the answer. Next 87. Under the scheme of CRPC, non-cognizable offences are private wrongs. B is the answer. Next 88. A discrimination against a man or woman only on the ground of dash would be violative of 15(1). All of them. So this was also deleted. Next 89. The objective resolution adopted by the Constituent Assembly on January 22, 1947 was drafted by Jawaharlal Nehru. A is the answer. Next 90. Right to the property was eliminated from the list of fundamental rights during the tenure of Morarji Desai. B is the answer. It was eliminated by 44th Amendment from 19(1)(f). It was deleted, but it was added as 300A as a constitutional right. Next 91. When the accused states, I will produce the share which I received in such and such robbery, which I have, this must be have, spelling mistake, which I have received in such and such robbery, which of the following are not admissible with regard to section 25. What is section 25? Any confession given to police is not admissible. An admission that there was a robbery, or admission that the accused took part in it, या फिर he got part in a property, a statement where to the property is. So I would say this question is wrong and it was not deleted, but it should have been deleted. How? There is no admission in section 25. It talks about confession first of all. But let's say if it is mentioned admission here, so admission that there was robbery, it is not admissible. Admission accused took part in it is not admissible. That he got part of the property, not admissible. Statement as to where the property is, this is also not admissible. So all of them are not admissible. D is the answer. Next 92. The maximum limit of the members of the State Bar Council is 25. C is the answer. Next 93. Specific Relief Act 1963 contains 8 chapter 44 sections. D is the answer. Next 94. What is the period of limitation for expeditious disposal of suit under Specific Relief Act? Within 12 months. C is the answer. It is mentioned in section 20C of Specific Relief Act. Next 95. A Chief Judicial Magistrate may pass a sentence of imprisonment not exceeding 7 years. A is the answer. Where this is mentioned, it is mentioned in section 29 CRPC. Next 96. Under CPC, foreign court means a court situated outside India and not established under the authority of India, and courts situated in India applying foreign law. All of the above. D is the answer. And where definition of foreign court is mentioned in section 2(5) of CPC. Next 97. Misuse of mechanism PIL means filing PIL for protection of private interest, या फिर oblique motive, या फिर only for publicity. All of the above. D is the answer. Next 98. What is meant by procedural ultra-virus? It is the non-observance of procedural norms by the rule-making authority. It may make the rule ultra-virus due to non-observance of rule-making authority and hence become void. It means lacuna in the procedure of law. No. So A and B are correct. D is the answer. Next 99. The ground of error of law apparent on the face of record is connected with which of the writ? Certiorari. D is the answer. Next 100. Under CPC, find the incorrect match. 5 is Revenue Court. This is correct. 7 is Provincial Small Cause Court. Yes. Section 9, pecuniary jurisdiction of court. No, pecuniary jurisdiction of court is in section 6. 9 is suit of civil nature. So this is wrong. 8 is presidency small cause courts. So C is the answer. C is wrong. So friends, here we have discussed all the questions of 16th All India Bar Examination, which was held in October 2021. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो इसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़. सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.